The recording has been started.
Thank you. Well, good afternoon, everyone. Thank you for coming today to participate in this hearing. It is 2:01 p.m. Pacific time. We're here located at the Idaho Department of Lands office in Coeur d'Alene, Idaho, and we are live via Zoom. This is the scheduled time and place for IDL hearing number CC-2022-NAV-22-002. This hearing is related to encroachment permit application L95S6007 filed by E3 LLC seeking authorization for a single family dock on Hayden Lake. Greg Toome and Leo Simpson objected to the application. The Idaho Department of Lands is the agency authorized to issue encroachment permits under Idaho law. My name is Andrew Smith. The director of the Idaho Department of Lands has appointed me to be the hearing officer. As you heard earlier, this hearing is being recorded. So please silence your cell phones. If you're joining us via Zoom, go ahead and mute yourself unless you will be speaking. And then when you do speak, please speak loud and clear. So the hearing will proceed as follows. I'm going to go ahead and start with taking roll. I will swear in those wishing to provide testimony today. I'll go over the record as I have it so far. Then I'll take testimony first from the applicant, from the objectors, and then from IDL. Following each testimony, the representatives of each party will have the opportunity to ask questions to the party testimony. And then finally, before we conclude, I'll review the next steps in the process. So with all that, let's go ahead and do introductions. Let's start with JJ on my left.
JJ Winters with the Office of the Attorney General. I'm assisting hearing officer today.
Tommy Fry Dock and Barge.
Mr. Fry, do you plan on providing testimony today?
Yes.
Leo Simpson.
Mr. Simpson, do you plan on providing testimony today?
I will defer that to our attorney.
Okay, thank you. Okay.
Rick Arthini. I'm still marked for this on behalf of Mr. Simpson, Mr. Travis Simpson, Mr. Greg Toome, Mr. Tom Cunningham, and Mrs. Lisa Cunningham.
Thank you. And so from your clients, which ones do you plan on offering? Will have provide testimony today?
I think they all plan on offering at least some minimal testimony.
Okay, thank you.
Sure, thank you.
I'm Tom Cunningham.
Eric Wilson, Bureau Chief, Resource Protection Assistance, Department of Lands.
Jennifer Barker, Department of Lands. Angela Kaufman, I'm a Deputy Attorney General, and I'm here today representing the Department of Lands.
Ms. Kaufman, who from IDL will be providing testimony today?
Ms. Barker will be, and Mr. Amer may be as well.
Mike Amer, Department of Lands.
Thank you.
Laura Moore, Department of Lands.
Thank you. And let's go ahead and go online. Let's start with Mr. Howland.
JD Howland, attorney of record for Youth Properties LLC.
And who do you plan on providing testimony today?
Nick Veith, Your Honor. Or, excuse me, Mr. Smith.
Thank you. Okay. I see Travis.
Travis Simpson.
Okay. Nicholas iPhone.
Good afternoon. This is Nick Veith speaking.
Thank you. And then iPhone 2.
Yes, I believe that's me. This is Greg Tom. Nice to meet everybody. I am the property owner of the adjacent property at 6673 Deep Shadow Lane.
Great, thank you. Is there anybody else joining us online? Perfect. All right, well, let me go around the room. I'll start with Mr. Fry. Mr. Fry, the testimony that you provide, do you swear or affirm that the testimony that you provide today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Mr. Simpson, same question?
Yes.
Thank you. Mrs. Cunningham?
Yes.
Thank you. Mr. Cunningham?
Yes.
Thank you. Ms. Barker?
Yes.
Mr. Amer?
Yes.
Thank you. Thank you. Mr. Simpson,
Yes.
thank you. Mr. B,
Yes.
thank you. Mr. Tom.
Yes.
All right, thank you. So my decision will be based on information provided in the record. The record consists of the testimonies given today, the exhibits admitted into the record, and the agency record. So the agency record so far consists of the February 8th, 2022 application, the February 9th notice application to the adjacent Latrobe owners, the March 1st email from Greg Tom, March 1st email from Leo Simpson, March 8th email from the applicant, March 18th submission of the easement document, March 18th notice of appointment of hearing officer and hearing. And then obviously that's it at this point. During the testimonies, go ahead and offer up any exhibits that you wish to admit to the record at that time. So before taking testimony, Mr. Rathanian, do you have any questions, procedural questions?
I do actually.
Okay.
The parties submitted a letter along with attended exhibits last Wednesday, which it's our understanding that should have been part of the record.
Okay, then so the letters as well.
Yes, sir.
Okay. Now the let's see. Like, hold up, just to confirm, to make sure that's.
Thank you.
So yeah, so April 13th, I see your letter. I see Mr. Howland's letter, I see IDL's written statement.
And in conjunction with our letter too, we also submitted the declaration of St. Johnson.
Okay,
So, thank you.
okay.
And that actually brings up a question for me. I think typically those exhibits are just made a part of the record. Would it be helpful to the hearing officer if perhaps counsel, if we could all just stipulate at this point given the low standard for admissibility and administrative proceedings, if we could just stipulate to the admission of those exhibits?
So stipulated.
No
Mr.
objection.
Howland,
Yeah,
Thank
that's fine by me.
thank you. I appreciate it.
Okay, well, with that, then let me just go over that really quickly. So that would be for the applicant. There's exhibits A1 through A7 as well as F1. Mr. Howland, is that correct?
Correct.
Perfect. And so all of those have been admitted. For the objectors, there was Mr. Sam Johnson's statement with those exhibits A through L, as well as Mr. Carthenian's letter and exhibits S1 through S11. Is that?
That's correct.
Okay. And so those were admitted, as well as IDO's statement and inspection report that was just provided this morning. Is that
Correct.
sounds good? You know, one comment I do want to make on, as I was reviewing the document, some of those pages were not legible. So I want to admit those to the extent that they're legible, if that's fair. All right. Oh,
Mr.
sorry.
Hearing Officer,
Yes.
could you maybe provide some specificity to us about what was not legible?
Sure, so I didn't go through and mark every page, but for example, if I go to exhibits S. Some of those older deeds were just hard to read.
To the extent it's helpful, those older deeds also indicate either their instrument number or the booking page number that they could be found in terms of the county's records. If perhaps you could take notice of the same. I'm sure that would be good.
Okay. Okay, I'll I'll do that, but just so everyone can see, let me go ahead and just share my screen real quick. For example, this was one of the pages where it was just a poor copy. And I'll take notice again, if the county's records are
As such.
forward, then we'll accept it as is, but with your letter and everything else provided, I'm not sure, for this particular part, how important it is. I know some of the attachments to Mr. Johnson's were there, and it looked to be the same document, but I imagine we'll go through that.
Exactly, yeah, there should be allowed to.
All right, well, thank you. Mr. Binion, do you have any other procedural questions?
I do not, thank you.
Mr. Howland, do you have any questions?
I do not.
Ms. Kaufman?
No, thank you.
So let me stop sharing my screen. Mr. Howland, go ahead and turn the time over to you.
Thank you. Mr. Veith, can you go ahead and unmute?
Okay, I'm unmuted.
And for the record, could you please state your name?
Nicholas Vernon Veith, that's V-I-E-T-H.
Okay. And what is your, how are you affiliated with Veith Properties LLC, the applicant in this matter?
I'm the owner of that LLC.
You're a member of that?
Yes, sir.
Okay. Is your wife, Tricia, a member of that as well?
Yes, sir.
Okay. And what is the relationship between Veith Properties LLC and Eat3 LLC?
Eat3 LLC is a 1031 exchange business out of Spokane, Washington. Sold a business property downtown Coeur d'Alene. They're holding that money while I'm buying the piece of property out of Deep Shadow and getting it developed.
Okay, so if I understand correctly, you're doing a 1031 exchange for the purchase of the property in Deep Shadow Lane.
Correct.
Okay, and is Eat3 LLC the facilitator or the accommodator of that 1031 exchange?
Yes, sir.
Okay, and you've seen the exhibits that were submitted and now admitted by stipulation in this matter?
I have.
Okay, and two of those exhibits, A2 and A3, is a master lease and a project management agreement between Eat3 LLC and Veith Properties LLC. You've seen those?
Yes.
Are you familiar with those documents?
Yes.
Okay, and I note that both of these documents that you provided me from your title package are not signed by Veith Properties LLC. Have those been countersigned by Veith Properties LLC?
Yes, they have.
Okay, and what was the nature of these two agreements? If you could just briefly summarize.
The agreement is to have the 1031 Eat3 handle the money from the sale of the property so that we could purchase the property through Eat3 out on Deep Shadow. That's a 1030.
Is it correct the 1031 exchange has not been finished at this point?
Correct. I think we've got about a month left.
Okay, but the title was conveyed to the accommodator in January of this year. Is that correct?
Yes, sir.
Okay, and during the process where you're doing this 1031 exchange, you have this project management agreement and lease for the property out on Deep Shadow Lane?
Yes, sir.
Okay, has that allowed you to make improvements and begin your development of that property?
Yes, sir.
And in the process, since closing in January of this year, have you had occasion to have the property out there on Deep Shadow surveyed?
I have.
Okay, to your knowledge, have the pins at the along the shoreline of Hayden Lake been located by the surveyor?
They have.
Okay, was that a professional land surveyor that you hired?
It was.
Okay, and have those pins that were located by the surveyor been flagged with stakes as well?
They have.
Okay, and in this matter, you're not seeking to construct a dock within the 10-foot buffer of the littoral line on the north and south boundary of your Deep Shadow property, are you?
No, sir.
Okay. And the property you purchased out there on Deep Shadow was actually conveyed to you by Barb and Dave Knoll. And what are the Knoll's relationship to you?
That's my mother and father-in-law. I don't know if they purchased it personally or whether or not their business, Black Sheep Sporting Goods, purchased it, but that is my my mother and father-in-law.
Okay, and approximately to your best of your recollection, when did the Knolls or when did your in-laws purchase the property out there on Deep Shadow?
About 15 years ago.
Okay, and what did you have an agreement between Mr. and Mrs. Knoll regarding your purchase of that property?
Yes, as soon as we got back up here and wanted to develop the property, they would sell the land to us.
Okay, what do you mean when you got back up here?
Well, we've been up here for some time and then sold the office, the business, downtown Coeur d'Alene. And then that's when it went to Eat 3. And then Eat 3, that's when we purchased the land from the Knolls.
Okay. So it sounds to me like you had an informal option to purchase that property out there in Deep Shadow from your in-laws?
Correct, yeah. And talking to both Dave and Barb, they basically held it for us for when we could purchase it and start the development.
Okay. And in the last 15 years, give or take, that your in-laws have owned that parcel, have you had occasion to go out there and visit the property?
I have.
Okay. How often?
Sporadically, anywhere from a couple times a year to I guess when we were really looking at it, developing and where to put certain things, it became monthly, if not a couple times a month. Usually during the summertime, not as much during the winter.
Okay. And have you ever observed anyone using the shoreline of the property?
No.
Okay. And is there a beach, or is it easily accessible, the shoreline of Hayden Lake on your parcel?
There is not a beach and it is not easily accessible. We'll have to build some stairs to get down there.
Okay. Have you seen anyone using the portion of your parcel that abuts Hayden Lake over the last 15 years?
I have not down on the water. Is that what you mean?
Correct.
No, I have not.
Okay. And there are not currently any dock or stairs constructed on your parcel to access Hayden Lake?
That is correct. I believe the Cunningham stairs, which would be the stairs to the south, they're a little bit on our property, but they angle away and go to his dock.
Do you mean the Tom's stairs?
Well, the Tom stairs do a little bit. The Cunningham stairs kind of wrap around. It's only probably maybe a foot or two on our property line, over our property line, I'm sorry.
Yeah, Mr. Veith, approximately, well, you own a boat, correct?
Correct.
Okay, and how long is that boat?
21, 22 foot ski nautique, little ski boat.
Okay, and do you anticipate any problem navigating and getting in and out of the slip as the proposed dock is, or under the alignment of the proposed dock?
No, and I've spoken with Mr. Fry about that, and he believes there's no concern as well.
Okay. I don't have any further questions for Mr. Veith.
Mr. Bethany, do you have any questions?
I do. At the time of the purchase of the property by Eat 3, and when I say the property, I mean the subject property underlying your application, did you conduct any title research on the property?
Yes.
You did. Okay. What did that entail?
We already had the majority of the title reports from my mother and father-in-law from the purchase. I believe it was about 15 years ago, give or take a couple months. So I'm well familiar with the property.
During that research, did you uncover any indication of any encumbrances upon that property?
Encumbrances above, meaning on land, or can you be a little more?
Well, the property itself.
Yes, I
Well,
believe there's kind of in the middle of the property up above. There's a easement for a drain field for, I believe, 2 of the adjacent property owners. And then down below, there's also an easement for pedestrian, vehicular, and parking up above as well, or not up above, but closer down in between Mr. Cunningham and our piece of property.
And would it be correct to say that that second encumbrance that you just mentioned, that was reflected in the warranty deeds between Mr. and Mr. Anderson and Mr. and Mrs. Verovsek, as well as Mr. and Mr. Anderson, Mr. and Mrs. Anderson, pardon me, and Mr. and Mrs. Gott?
I'd have to look at it. I'm not sure.
Okay.
I know that there's 2, one specific for a drain field up above, and then one specific for parking, vehicular, and pedestrian.
Thank you, Mr. Beeth. I appreciate that. In coordination with this research, did you get a commitment for title insurance?
I believe we did. I'd have to look at that as well. I think we did, yeah.
Thank you, Mr. Beeth. I have no further questions.
Ms. Kaufman?
I don't have any questions. Thank you.
Okay. Mr. Helmy, I have a question for you. Who would be the best person to ask about the dimensions of the proposed dock? Would that be Mr. Fry or Mr. B?
Mr. Fry.
Okay, I'll wait then. All right, Mr. Helmy, do you have a witness or someone would like to provide testimony?
Sorry, what was that?
Oh, sorry, do you have another person you'd like to question or provide testimony?
Yeah, Mr. Fry.
Yes. You like me to answer any questions, or?
I was going to say this, I have questions for you first.
Yeah, Mr. Fry, why don't you begin by stating your name for the record?
Tom Fry, F-R-E-Y, Fry Dock and Barge Incorporated.
Okay. And as in, you're affiliated with Fry Dock and Barge Incorporated, correct?
Yes, yes,
Okay. And how long have you been affiliated with that company?
30 years.
Does the name suggest you build and install docks in the area?
Yep, that's what we do.
And briefly explain your experience with installing docks in Hayden Lake.
Well, it's, it varies from spot to spot to spot, but what we do is we design the dock around the rules and around what the homeowners need and the particular piece of property, and also the lake bottom. So.
Okay, you mentioned with the rules, what rules are you referring to?
The 700 square foot max, nothing wider than 10 feet anywhere on the dock, the 10 foot from either property line. There's a extension into the lake. There's just a number of them, but those are the basic ones that we look at when we're addressing a piece of property.
Okay, and are those the rules promulgated by the Department of Lands for single family docks?
Yes.
Okay, and you're familiar with those rules?
Yes.
Okay. Were you hired by Youth Properties LLC to design a dock for the property it's contracting to buy on Deep Shadow Lane?
Yes.
Okay. If you just explain the process of how you went about designing a dock for that parcel.
Well, what we do is we look at the parcel and then we look at the adjacent, docks in there for extension. And then we talk to the client and say, hey, what's the priority here? What's the length of the boat? What's the width of the boat? Is there going to be a boat lift in there eventually? Is it, where do you want the maximum protection for the boat? How do you want the boat to sit? And then we go from there to determine, what fits and what's best for our client.
And did you assist Mr. Veith and Veith Properties with filling out a joint application for a permit?
Yes, sir.
For the property on Deep Shadow?
Yes, generally what happens is I meet with the client, we talk about the property, we talk about the dock, what they want out of the dock, whether it be a single slip, a double slip, an L dock, whatever that they're looking for. And once we come up with a design and where we want it on the property, then I make application for that particular client.
In the application is a diagram, an aerial diagram of the proposed dock. Is that something that you prepared?
Yes.
Okay, and it has the dimensions on it in relation to the neighbor's dock property line and the corresponding property lines.
Yes.
Okay, and those are those measurements on there? Are those all measurements you calculated?
Well, I look at the shoreline and I look at the property lines, and then in this particular one, we submitted the application and we were told that the riparian rights were to be altered a little bit because of the way the shoreline was. So we did that and then made our application.
Okay, and when you inspected the property out there on Deep Shadow, were the pins at the shoreline marked for you?
Yes.
Okay, did you take any measurements off those pins?
Yeah, we pulled. It's hard to tell, when you're dealing, what I deal with is from high water out. I don't look at, I have to look up the hill and see where the rest of them are, but my job is kind of like the state's job. I deal with one, where the riparian lines I think they are, because you can't go off of a Kootenai County assessor's shot. You can't go off of, you basically look at the shoreline and then, say, hey, is this where we're looking at the right idea for the riparian rights for that particular piece of property? And it changes depending on if you're in a little bay or if you're on a point or where you are. So, this particular shoreline I thought was fairly straight, but there's some questions there, I guess, in which way the riparian rights, lines run, and that's not for me to determine, I guess.
Yeah, Mr. Fry, did you also confer with Mr. Veith's surveyor?
I believe I spoke to him, on the, what the total shoreline measurement was, because if you looked at it on, how we normally do this is we pull up the county assessors plot maps and their, their website and get the links off of that. In this particular case, it ended up being, I think, 2.5 feet or something like that, less than what the county showed.
Okay. Was that surveyor with Advanced Technology Survey in Engineering in Hayden?
Yes. So.
And is it your proposal or does your proposal allow for a 10-foot buffer from the littoral right line on the north and south of the Veith parcel?
Yes.
Okay. Is there any reason why you believe that 10-foot buffer will not be, why you'll not be able to allow for that full 10-foot buffer on both the north and south?
Oh, sir.
Okay. No further questions from Mr. Fry.
Thank you. Mr.
Thank you. Yeah, just a few. Sir, you on a couple of occasions mentioned riparian rights generally, and then you also mentioned riparian right lines. Your testimony, you're not here to speak to riparian rights or littoral rights as a general matter, right? You're just talking about the right lines.
What we go off of for the state to determine where that 10 feet is.
Civil lines. Just the lines, not
Yes.
the underlying village. No further questions, thank you.
Ms. Copeland?
No questions.
Okay, I have a couple questions. Let me do this because I want to pull up on the screen the application of the diagram, so I'm gonna try. Understand the dimension of the dock. Just a moment.
Mr. Hearing Officer, I believe it's page 22 of 27.
All right, can everybody see this diagram?
Hmm.
Okay. Mr. Farr, do you mind just starting from the shoreline and just identifying each part of the proposed structure and its corresponding dimensions, please?
So you have the fixed pier, which is moving from the right side to the left. You have a 4x10 fixed pier, and we do that, especially in this case, because he's gonna have to have something to land stairs on. It's, it's steep. And then the next is a removable gangway that's 3x20. But 17 feet of it's over the actual water. And then you have the floating slip dock itself. It's held in place with 3 piling.
Okay. I'm going to I'll try to zoom in. So basically what I was wanting to do is just confirm the square footage. And so starting waterward from it, looks like this part here is 10 feet wide
Mhm.
and 38 feet long.
Mhm.
And I see this finger right here is 25 feet long
Mhm.
by 4 feet wide.
Mhm.
Could you fill in the blank for me for this square here, starting at the edge of the slip to the back, going to the gangway for me, please?
I don't have my drawing with me right now. I believe it's 8
8 feet between
from the head. Yeah,
from here to here.
I believe so. Sorry, I came straight from the job.
Okay, and that'd be 14 feet,
10 feet.
or the 10-foot slip plus a 4-foot finger over this way.
Right. Yeah.
Out of curiosity, a lot of docks will have the triangle supports up here at the front.
Mhm.
Does this one, do you plan on having those on this one?
No.
Okay.
We don't do a whole lot of them anymore because there's so many pontoons and a lot of the new ski boats are all squared on the front. So
Okay.
it makes it, not beneficial for the homeowner.
Okay. All right, thank you.
Mhm.
Mr. Howard. Do you have anybody else to provide testimony?
No.
So thank you. Mr. Opinion?
Thank you. So my intention is to provide a brief presentation, after which I think it makes more sense to get witness testimony, if that's acceptable to you, Mr. Smith. I'll proceed accordingly.
Sure.
As you know, I'm here on behalf of Mr. Simpson, Mr. Travis Simpson, Mr. Greg Tome, Mr. and Mrs. Cunningham. The Simpson family, collectively, Mr. Simpson and his son Travis, own several parcels in the surrounding area. And the original conveyance documents of those parcels include an express grant of riparian littoral rights in regards to the subject property, the property we're here for. Of course, those original conveyance documents were made to the predecessors in interest of either E3, Mr. Veith, or the Knowles. But those documents, which have been provided along with our correspondence from last Wednesday in full detail, so I won't belabor you in terms of going through each one, but those documents expressly recognize such a conveyance of littoral rights. The history in terms of those conveyances are important. You have, trying to clock back to about the late 50s, early 60s, and you had Mr. and Mrs. Anderson who owned quite a bit of property in the immediate vicinity of that area. A part of the property associated there is now what is regarded as being secondary parcels, tax number 5722, 5720. And you can see those reflected in our exhibit identified as S6. Now, Mr. Anderson effectively sold those parcels to his friends. He sold it to them for $1. And a part of why he did so was to capture the ability of those friends to access and to utilize the lake. And that distinction there is critical because we're not talking about simple access. We're not talking about a simple easement down to the shore. We're talking about an express granting of riparian rights to the predecessors in interest. That is a critical point with all due respect in terms of the hearing statement that was prepared to discuss the issue of easements. And that is correct. Those parcels do have an encumbrance by way of an easement upon the subject parcel. But it's not a simple easement. Again, it's the granting riparian littoral rights. I won't belabor the point in terms of going through the importance of encumbrances and easements and how they're protected under Idaho law. I believe that's well established, the history, the case law set forth in our, Mr. Smith, if you have any questions in that regard, I'll be happy to address them, but I think it's effectively established. You heard Mr. Veith's testimony in terms of conducting the necessary title research and the commitment to title insurance itself. And Idaho law is similarly well established in the fact that a purchaser of lands takes subject to those encumbrances, either contextually if they have direct knowledge of those encumbrances or constructive knowledge. And I believe Mr. Veith's testimony clearly establishes the fact that he indeed has constructive knowledge of the encumbrances at issue. Simple, as reflected in our letter too, such simple title research and a commitment for title insurance reflects just a multitude of encumbrances on the subject property. And those encumbrances once again include the deeds, the original conveyance warranty deeds that provide and set forth the grant of riparian rights as set forth in our letter, mentioned numerous times today. So fundamentally, I mean, the entire point is with the conveyance of such rights, it's unavoidable that the construction of this dock would infringe upon the riparian littoral rights enjoyed by Mr. Simpson and his son. It's just a fundamental reality because I mean, you're talking about a physical object that would impede such access. So from a conceptual point, if there's a protection afforded under easements and Idaho law and a treatment of easements and such encumbrances. A secondary point is under IDAPA 2003-04.001.02, which is the signature requirement for such applications. Inherently, given this history, given these points, approval of the dock would violate the express language of that provision as signature requirement, particularly its language that expressly provides that the grantor of such littoral rights, however, shall no longer be eligible to apply for an encroachment permit. It's those two traditional notions of easements and the running of easements and close inspections of the conveyance documents at issue shows that these are pertinent easements that have run with the land. They have been drafted in a way that is no way engrossed, it's no way limited to Mr. Johnson's buddies that he had sold the underlying property to. They're never tenant, they run with the land. So IDAPA, the signature requirement of IDAPA requires that this application be denied through its express terms. An important point too, and it was not reflected in our letter, but I think it bears highlighting, is the recent Supreme Court decision, the Idaho Supreme Court decision in Byrd v. Idaho State Board of Commissioners. And what the state Supreme Court did is it made it abundantly clear that so far as there's an argument in terms of the existence of an ownership of riparian or littoral rights, it's, with all due respect to the Department of Lands, it's not an issue for the Department of Lands to adjudicate. That is clearly an issue for the courts. The procedural safeguards set forth by the rules of civil procedure in terms of traditional discovery, everything that's part and parcel of litigation, that is the mechanism to dispute, or excuse me, to investigate and explore any sort of disputes in terms of the meaning of conveyances, the meaning of deeds. And really, the expressive language of the decision itself also goes so far as to say that in the event that there's any sort of dispute in terms of such factors and in terms of such meanings, the IDL's only options is not to exceed its statutory authority is to deny permit applications such as what's before you today. So if you look at it as a whole, you have IDAPA, which again, it's our position that it precludes the granting of the application as a technical matter through its express language. Secondarily, if there's any argument that somehow IDAPA does not apply in that sense, then Byrd makes clear that really the only argument you have taking this outside of the auspices of IDAPA is some sort of determination in terms of what the underlying grant of riparian rights really means and what it does not mean. And again, the Idaho State Supreme Court has spoken on the issue and has made clear that this is not an issue for the IDL to determine, and because of that, the only option is to deny the application. As you know, with me is Mr. Simpson, his son Travis Simpson, and the Cunninghams. And at this point, I think it makes sense for them to identify who they are, once again, the properties that they own, and how they feel about the application position on it.
So yeah, I'm Leo Simpson. I live 150 feet from the proposed dock site. And I also own a secondary property that has the riparian rights along with pedestrian and vehicular traffic and parking on this parcel that was surveyed by Advanced. One of our exhibits shows that this surveyed area by Advanced was also surveyed by Advanced in Crete, and that is the subject area of the easement for the secondary property. My son also owns a secondary property, and it too shares the vehicular and pedestrian rights and parking and riparian rights to the shore and beyond. And I do have copies that are better than the one that they have on the record if we need to show what those easements specifically state. But that's my concern, is that this is not my home property, although my home property also has this easement, ironically, because another secondary parcel was rolled into my home property. And so those riparian rights didn't go away. So the whole idea then is the value of these secondary properties was to be able to come down, park their car, walk down to this open area property and then go down and use the lake. And obviously, that's their market value. So if the dock is allowed to be put in, then where do those riparian rights go? It's like all of a sudden, those properties are worth much less if you can't come down and utilize the area for parking and utilize the water, access the water. So, and it's rather obvious that that dock would prevent that from happening. So those are my principal. Can you think of anything else that I need to mention in that regard? Okay, so my principal concern with what's going on, because I don't know why I wouldn't have continued my riparian rights that have been there since 1963. And that was, basis of my concern.
Mr. Howell, do you have any questions for Mr. Simpson?
I do, thank you. Now, Mr. Simpson, you mentioned that you had an easement prepared by Advanced Technology Surveying of the easement area.
That's correct. It's one of the exhibits.
And that is one of the exhibits you filed in support of your objection.
Pardon me?
And that is one of the exhibits you filed in support of your objection, correct?
It's shown as a crosshatched area on the entire finger of the E3 LLC property from, here it is right here.
JD, it's our exhibit S6.
I was just gonna, thanks, Rick. I was just gonna ask Mr. Simpson if he has exhibit A5 in front of him.
I do.
Okay. A5 is the survey that you referenced earlier in your testimony.
What it is a,
Well, my question to you,
it
A5
shows-
is the survey
well,
you
not-
referenced earlier.
well, not exactly. What it is it took the meets and bounds description from the easement and showed where that appears on the plat map.
Mr. Simpson, earlier you testified to having a survey conducted of the easement area, correct?
I don't know if I said that or if but the fact is, the two properties that have this easement with the meets and bounds description, we wanted to know where the meets and bounds description is. And so it turns out it's the area that was identified by survey.
Okay, and that is exhibit A5.
Yes,
Okay, and that document states that no field work was done in preparation of that exhibit, correct?
that's correct.
What that is just an exhibit showing, based on the meets and bounds of the easement area, where that easement lies with respect to the Vieth parcel.
That's correct.
Okay. And you don't have any information by way of surveys today as the width of the Vieth parcel at the Hain Lake shoreline?
Well, that's an interesting point because the new survey stake is a little higher up than where all the other survey stakes were located. So when the survey was done, the new survey stake appeared and all the old survey stakes disappeared. But the meets and bounds description of those two properties, of the three properties that go back to 1963 easement, specify a 52-foot shore length. And that I can speculate on why that was done that way, because the high water mark for the lake was not determined until 1964, the next year. So they used 40 years of data to identify the high water mark in 1964. These easements were written in 1963. So most likely in 1963, they measured the shoreline from point to point on the on what they determined to be high water based on pollen or whatever it was. And the measurement was 52 feet. And
Mr. Simpson,
subsequently, then that was changed in later years once the high water mark was identified.
Mr. Simpson, the question, I guess, is, have you had a professional land surveyor independently verify the width of the VEIF parcel at the ordinary high water mark of Hayden Lake?
I have not.
Okay. And so your only information that to dispute the width of that parcel at the high water mark is this call out on exhibit A5.
I don't know what a call out is.
Well, the distance, the width call out of 53.2 feet.
Yeah,
And Mr. Simpson, you own, is it 6659 Deep Shadow Lane?
no. I don't write myself letters, so.
Or 6671?
6671, thank you.
Apologize for that. And your property, and you have residence construction on that property, correct?
That's correct.
Okay. And that parcel has access to Hayden Lake, correct?
That is correct.
Including a single family dock, correct?
That's correct.
Okay. And can you tell me how the proposed dock would interfere with your right to exercise the easement on the VEIF parcel?
Well, only in the access area. The dock itself would not affect my home property. It would affect my secondary properties. My secondary properties are the ones with the easement rights and the riparian rights.
And those
So I'm
secondary,
not objecting on the basis of my home property with the exception of access, which apparently the Department of Lands doesn't oversee. So there is an access issue, but in terms of the dock itself, my home property doesn't object to that. It's the secondary properties that have the riparian rights.
and your secondary properties are unimproved, correct?
That's correct.
Okay. And so can you tell me how the proposed dock would interfere with the rights of the secondary properties to use that area for pedestrian vehicle or parking purposes?
Well, that's not the only thing that's included in those easements. Also the riparian rights that those properties have. So try to imagine going down to the shoreline and going for a swim or using your kayak or going fishing. There's a dock there. So, to me, it's an obvious thing that a dock sitting there is going to interfere with the use of the water by those two properties. And my home property does have that same easement right.
In what historical use have those secondary lots made of the of Hayden Lake on the VEIF property?
Well, I don't know before I acquired them, but subsequently, they've been properties that I've been holding for investment and also for my son's family. And so as a secondary properties to my primary property, they have less value than if I didn't have a primary property.
Mr. Simpson, how long have you owned these secondary properties?
Oh, approximately 10 years, 10 or 12 years. Huh? Okay.
It's in our exhibits.
Sorry, what was that?
It's in, I think it's most clearly delineated out in Sam Johnson's declaration.
I don't have any further questions for Mr. Simpson.
Ms. Kaufman, do you have any questions?
Thank you.
Thank you, Mr. Simpson. So would you like someone else to provide?
Sure.
I'm Lisa Cunningham with my husband Tom, and we're own the property 6675 Deep Shadow Lane. And our objection is just basically, we don't believe that Mr. Veith owns the littoral rights or riparian rights to that lot. We've owned our place, built it actually in 1991. And we've been coming to the lake in the late 80s and knew the previous owner to Mr. Simpson, Orville Johnson, and he could never do anything with that lot. He always referred to the secondary lots up there. He couldn't build on it, couldn't put a dock in. And he in fact went down to the county when property value rose and the taxes rose to get his taxes reduced on that particular property because he did not have the right to use the waterway, as far as it wasn't waterfront property for him, because he had to yield to the properties up above. So that's about all I have. It's just objection. I don't believe that the riparian rights are that lots anymore.
Thank you. May I ask a question? Yeah.
If this dock permit was permitted, what would that entail on as owners of the adjacent property? What would that entail for you on a quality of life sort of daily basis in terms of interference with the use of your land or just peaceful enjoyment of your property?
Well, it would be better. And if I was driving the boat, it would make me harder to get in and out of the slip. But, and you don't know what it would really bring, especially if there's other people that would be coming down with their littoral rights, that would be more people using the lake.
Do you have any other questions?
I do not.
Okay, Mr. Howland, do you have any questions?
Just a few. Ms. Cunningham, do you know the width of the shoreline on your property?
I believe it's 79.8 something.
Okay, and you do have a single family dock
We do,
constructed in front of your property in Hidden Lake?
yes,
Okay, and that's constructed towards the southern littoral right line of your
Correct.
parcel, correct?
correct.
Okay, so how would a dock constructed on the Veith parcel interfere with your ability to access your current existing dock?
You haven't seen me drive the boat. So when the waves come in and stuff and wind, so I just state the fact,
How large is your boat?
it's 20 feet.
And for the record, you do on your parcel, which is 6675 Deep Shadow Lane, have the ability to access Hayden Lake.
Yes,
Okay. And how would the proposed dock interfere with your right to use the easement area for pedestrian, vehicular traffic, or parking purposes?
how would the dock?
Yeah, that's my question.
I'll object to that. She did not articulate that as being a basis for her objection to that.
My basic objection is I don't believe that he has the riparian rights to that parcel. That's our main objection.
Do you want to rephrase the question, Mr. Howland?
No, I'm fine.
Do you have any other questions, Mr. Howland? Ms. Cunningham? Ms. Cunningham?
Yes, just one final. Ms. Cunningham, have you ever had occasion to use the shoreline of the Veith parcel since you've owned that part, since you've owned your property at 6675?
And I'll object to that with all due respect to Mr. Halloran. We're not making the claim, or we're not making the argument that the Cunninghams have a easement or any sort of riparian rights to the Veith property. Again, that's an argument that's forwarded by Mr. Simpson and his son.
So to make sure I understand, so the Cunninghams do not have an easement.
That's correct.
Okay.
That's correct. Their objection, and not to paraphrase, but I'll paraphrase for sake of simplicity, is really kind of the concern in terms of what development, creation, and operation of the dock would mean to that as an adjacent parcel owner. Okay.
All right. And Mr. Allen, do you have another question?
No, I just think it's a, proper question on the broad rules of admissibility that apply to these hearings. Just trying to understand why the Cunninghams are concerned with the proposed dock and
Okay, well, based on my understanding, if they're not claiming an easement on the applicant's property, you're asking them about an easement that they don't have. I don't understand.
that's fine. If they want to, I don't care. We'll move on.
All right, do you have any other questions for Mrs. Cunningham?
I do not. Thank you.
Anybody else who'd like to?
I defer to Mr. Cunningham, Mr. Tome, and Mr. Simpson if they would like to offer any testimony, or if they would simply like to concur with the presentation that we made today and to concur with the letter and exhibits that we submitted.
Yeah, sure. Yeah, this is Greg Tom, and I've got a couple comments. Is that okay?
Of course.
Yeah, outside of, also, I don't believe that, at least from what I've seen and been told, that that property has actual rights to build a dock. The other things that concern me is that, I know the Department of Lands was out there on my property looking at that, the shoreline. One of the problems is that it's really hard to get into my driveway. Right. And you got to back down very close to the edge of that cliff to get into my driveway. Any kind of structure there could cause problems, and it would be very unsafe. The other concern I have from a safety perspective is the way this dock has been configured. You've got a 25-foot slip to get a 25-foot boat in there from the north. It is 24 feet from my dock. Right. I own a 25-foot boat. I know how hard it is to turn a boat on that lake coming in from the north. I don't know if anybody else in that room does. I do. I do it all the time. You are asking for an accident trying to pull a boat from the north into that dock. Right. So, I mean, I couldn't believe when I saw the design. I was like, why wouldn't somebody just come in straight in on the design with a dock or with a boat for that dock, knowing the way that property is situated? So that's just a safety issue. I've got 4 children that are there all the time. I feel like we're asking for a problem. So, I mean, that's my comment, main comment. So one thing I didn't understand in the beginning is, when Mr. Beath and Mr. Holland were talking, I didn't understand how Black Sheep played into this. I don't know, does Black Sheep own the land or something? That would confuse me. Right. And why that was thrown out there. I mean, I work for a company that hires thousands of people in Idaho. I don't know if that's irrelevant. So that's all I'd say. Thank you.
Do you have any questions?
I do not. Thank you.
Mr. Allen, do you have any questions?
I have a few. Mr. Tome, you have a single family dock. It's benefits your parcel, correct?
Correct, I do.
Okay. And do you know when that was constructed?
Boy, it's probably been there for at least, I'm guessing 35 to 40 years.
Does that predate 1975 to your knowledge?
As a math major, 22 minus 40 years would, yes.
Do you have any
Actually,
knowledge
it
of?
doesn't.
Sorry, what was that?
No, it actually probably doesn't. If it's 40 years, if it would be 50 years, it would. So,
Okay.
Yep.
Did you make application for that dock, or was that made by your predecessor in title?
That was done before I purchased the property.
Okay. And your current dock is constructed just along the southern littoral line of your parcel?
It is correct.
Did you obtain the consent of the owner of the then Veith parcel? I guess I'll strike that because you testified you didn't make application for the permit at the time. Now,
I mean, just
how would the
date-wise,
proposed dock?
just date-wise, maybe I'm confused on what you're going for, but I mean, that dock was in existence before the Veith even bought the parcel,
Okay.
correct?
And have you made any modifications to the dock since you've owned that parcel?
I did, yeah. I took off an upper deck that was unsafe on it, correct,
Okay. When was that?
last year.
Was that permitted?
No, because I didn't realize I had to get a permit to do it.
Now, you stated that in your mind, the proposed dock might interfere with your ability to access your parcel by vehicle.
Correct. No, I didn't say the dock did. I said if you put a structure or a stairway down that steep bank to get to a dock, that could very well restrict getting down my driveway.
Okay, well, what about the proposed application, which includes the gangplank and stairway, would interfere with your ability to access your parcel by car?
I think it'll be very tight where the stairway is to get down that area where my driveway is. It doesn't mean it can't be done. I'm just saying it is very, very tight.
You acknowledge there's no proposed improvements to be constructed on the upland area of the Veith parcel.
I don't follow what you're saying. Maybe repeat that in a little more clarity.
Well, there's currently a flat gravelled area that is included in the easement area that we talked about today, correct?
Oh, correct. Yeah, that's the easement I have to get down my driveway. Yes.
Okay. And there's and you're familiar with the application that's been filed with the Department of Lands in this case, correct?
Correct.
Okay. There's nothing proposed to be constructed on that flat gravel area as a result of this application, correct?
You want to pull it up on the screen so we can look at it together?
Well, I'm just trying to get to the bottom of your statement that this proposed application might interfere with your ability to get in and out of your parcel by vehicle.
I think it would depend on the stairs, how they were built. And if they came across that, if they came across the flat area along the top of that ledge, it would cause an issue. And, as you know, that picture is not very detailed on the dock, right? I mean, it doesn't even have full dimensions, so.
And over the last approximately 35 years you've owned that parcel, have you had occasion to use that easement area to access Hayden Lake?
Once again, Mr. Tell is not making the argument that he has an easement to the Veith parcel or to the subject parcel. So just to clarify that.
Yeah, my issue was one of the fact that, again, I don't believe that parcel has rights, based on everything that's been presented, but secondarily, it seems to be a pretty big safety issue, the way that dock was designed.
No further questions.
Do you have any questions?
Yes, I do have a couple of questions for Mr. Tom. Hi, Mr. Tom, this is Angela Kaufman. I'm a Deputy Attorney General for the Department of Lands, and I just have a couple of questions for you.
Mhm.
So when you mentioned as part of your testimony that you had removed a portion of your existing dock, I think, and I don't want to put words in your mouth, so correct me if I'm wrong about this, but there was an unsafe upper portion, is that correct?
It was, yeah, it was like a double decker dock when I bought the place. Right, and I was like, do I fix it or do I remove it? And being I had 4 children, I'm like, boy, I think that's a liability issue. So matter of fact, I talked to Mike about it, last month. Because I didn't do a permit for it to remove it. So, I guess I got to do a new permit to remove it appropriately. So.
Did you do any other work to the dock at that time?
All I did was I just filled in the boat slip underneath it where that was. So I didn't change the square footage. I just assumed I didn't move the dock. So it was exactly like it was before, just shrunk down.
With the removal of the boat slip, then where do you intend to park your boat, excuse me?
Oh, I don't park it in the boat slip. I park it next to the dock.
Okay, and on which side of the dock do you park your boat?
On the north side of the dock.
Okay.
Yeah, my issue with what maybe I said it wrong or not, it wasn't crisp enough, but turning into the dock that was proposed from the north, if you have a 25-foot boat and you only have 24 feet, is a really difficult task. So, especially when the waves are out there. So it just seems very unsafe to design it that way. Maybe practicality doesn't come into this discussion, but just given my comments.
I don't have any further questions.
So I have one question. Again, I want to pull up the document and share on the screen so everyone can follow along. All right, this is a page from the application. And in this diagram, we have the applicant's property here, the proposed dock. We have these northern and southern littoral lines here. So, Mr. Thomas, so this is I'm pointing right now to the northern littoral line. This is the one that would be shared with you. Is that correct?
Correct, yes.
Okay. Do you agree with the location, the placement of that littoral line? Is that accurate?
I can't agree with that. I have no idea.
Okay.
I have no idea.
All right. Thank you. Do you have anybody else you'd like to?
No, but I guess what I would comment is you can see if you were going to enter that from the north, how tight that is for a 25-foot boat. You know what I mean? That's pretty tight.
Thank you.
I defer to Mr. Simpson, Mr. Travis Simpson, if he wants to offer any testimony.
Yeah, can you see and hear me okay?
We can, thank you.
Perfect, thank you. And thank you for your time. We have a secondary piece of property that has the literal rights. I have 3 children. We love to come out to the lake every summer. We spend a lot of time there. I grew up on Hayden Lake, swimming in the water, boating on the lake. And as you know, with all the boats going by, we love to swim in the water. It's hot in the summer. We get in the water, we splash around, and we swim on the shore all the time. And so you can't swim there if there's a dock there. And it would adversely affect the value of the properties that we jointly own. And so, there's just no way around it. It's an unfortunate circumstance that we're on a meeting having to discuss this, but I understand it. It's just one of those things that I don't want my kids swimming out in the middle of the lake either. And so there's only so much swimming you can do between these docks, and it's a nice body of water for the kids to swim, splash, play around, and we don't have to worry about a boat passing by hitting them with a prop. I did have that happen to one of my friends as a kid. So it's something that's important to me, that keep the kids out of the body of water, closer to the shore. And I do spend quite a bit of time there in the summertime. And I don't want to lose my rights as it relates to the property up above. Thank you.
Thank you.
Mr. Allen, do you have any questions for Mr. Simpson?
I do not.
Ms. Kaufman, do you have any questions?
No, I do not. Thank you.
If I may, yes, just to circle back on a couple of points that I think are important to emphasize. First of all, I want to be clear that we're not necessarily arguing a severance of any sort of rights that E or E3, or pardon me, Mr. B or E3 may have, frankly, we're not even broaching that issue. I know there were some comments in that regard, and I do want to clarify them, because I want to make clear that we're not making that argument. The argument that we are making, though, is that Mr. Simpson and his son, in contrast, do have clear riparian rights to the property issue. And that's really what we're here to protect and really trying to focus on. In that regard, two secondary points too, is in a sense, I think it's kind of the elephant in the room that this might come across as pettiness amongst neighbors or potential neighbors. And it's quite easy to kind of see it along those lines if the context is not indeed appreciated, that there are real secondary concerns from the secondary parcel owners in terms of the value of their land. And historical usage or lack of historical usage, those are all interesting topical points to address, but at the end of the day, there's those rights, those legally recognized rights, provide some sort of economic value that those parcels enjoy. And the law protects that. It's not something just to be cast aside because there's a more compelling argument of fairness, or you have a right, I don't have a right. Well, how's that fair? Well, the law speaks on the issue. And here, unfortunately, we have set of circumstances where you have operative easements in place, and they say what they say. So I appreciate the heartache and the appearances of some of the arguments, but it's important to really kind of bear that in mind. And in terms of the layout of the dock, I think it's important not to put the cart before the horse on that one. It's fundamentally, the signature requirement is clear that since those riparian rights were granted by E3's predecessors in interest, they're simply precluded from submitting an application at all. It's the whole issue of whether the layout is appropriate, or if it adversely encumbers the use of the docks to the north or to the south. Quite frankly, those issues are immaterial. We have a set of procedures that's very clear on the point, and we have operative conveyance documents that are very clear. So with all due respect to the arguments raised and made, I mean, they were very well done. It's important to bear in mind that, again, those just simply do not come into play. Thank you.
Thank you. Okay, Ms. Kaufman.
If I could have maybe 5 minutes to talk with my client, and then we'll come back and be prepared to go on the record.
That sounds good. Yeah, we've been going strong for about an hour and 20 minutes. So 5 minutes, 10 minutes.
Sure.
Let's do 10 minutes. Let's just. do
Yeah,
10
to give
minutes.
everybody a break, maybe if we could say 10 minutes and then we'll be back. Would that be all right with you? That's, is that okay, Council? Thank you.
Mr.
Hey,
Howland.
Nick, you there still?
Mr. Howland.
Yes, I'm here.
That's
Oh,
fine with me.
okay. We're taking a break. Give me a ring.
Oh, yeah, sure.
Thanks.
Thank you, Steve. Back in 10 minutes. Chris, do you mind stopping the recording and then we'll turn that back up when we get back?
Recording has been resumed.
Thank you. All right, well, it's 3:34, back on the record. So again, we'll turn the time over to Ms. Kaufman for her presentation.
Thank you, Mr. Hearing Officer. Again, for the record, my name is Angela Kaufman, Deputy Attorney General for the Department of Lands. I just have a couple of remarks in the way of legal authorities. And then Mr. Amer is going to talk a little bit about littoral right lines. And then Ms. Barker will proceed with IDL's hearing statement as slightly modified. So the first thing I want to make clear, as and IDL mentioned this in their hearing statement, is that well, let me back this up by saying it's not clear to me, reading the pertinent deeds, that the upland, that the Johnsons and their successor, or that the Johnsons conveyed riparian rights. I think at most they conveyed an easement, perhaps for riparian rights. Now, what that means in total, you know, I couldn't tell you, but I do know that under the Department of Lands administrative rules, an easement interest in riparian rights is insufficient to obtain an encroachment permit. So we would be in a situation, I would think, where if the hearing officer finds that he has jurisdiction to resolve the riparian or the littoral ownership issue, that the upland owners, those upland owners, secondary lot owners, have at most an easement for those riparian rights, and they would not be able to obtain an encroachment permit. The other thing too, you know, I would say about Byrd, having argued the case before the Supreme Court, is it does make it very clear that IDL does have lacks authority to determine ownership for littoral rights. So, you know, if you do find yourself in a position of being unable to determine who owns littoral rights, certainly denial would be appropriate. However, as I reviewed this with the Department of Lands, our review of the pertinent deeds and information was that there was an easement conveyed, and that the easement deeds, the reference to riparian rights was describing the underlying property, not the easement itself. With that, I will turn the time over first to Mr. Amer to talk about a couple of issues, one of which was littoral right lines, which I believe you raised earlier, and then again, Ms. Barker will follow.
For the record, my name is Mike Gamer, the Resource Supervisor for the Navigable Waters Program, Coeur d'Alene office. Prior to the hearing today, I worked on an exhibit that will submit to the record. It was based off of page 12 of 27 of the applicant's exhibit, and it is the topographic map survey that was done by Advanced Technology Surveying Engineering. And what I did was I printed out that page on a 11x17 paper. I cut the scale section off of the map and taped it closer to where the shoreline is. I then zoomed on the copy machine to 250% to get a much more zoomed in version of said topo map, with the scale still at that same exact scale as it should have been for the original photo. And what I noticed was that on the southern boundary of the applicant's property, the property pin stops at approximately at elevation 2256. The ordinary high water mark for Hayden Lake was adjudicated to be at 2242. So this is quite a ways up above ordinary water mark. The other pin on the north side of the property line appears to be right at that 2242. On this figure, I drew an orange line. That is the 2242 ordinary high water mark that showed up on the topo map. So for the southern boundary that stops at 2256, I used a ruler to extend that property line to the high water mark, which is the practice that IDL uses to determine riparian right lines and riparian area. If the property stops before the high water mark, you extend that property line on that same trajectory to the high water mark. A couple things to note was that when I did this scale, 50 feet equaled 1 and 1.5/16 of an inch. Therefore, 1/16 of an inch was equivalent to 2.86 feet. The shoreline that I measured based off of the dark black line, which was the plot line or the plat line, I measured that to be 1 6/16 of an inch, which was 62.86 feet. According to deeds and the application, it came pretty close to what I believe was 62.3, is what I think the survey called for. However, when I extended that property line on the south to the ordinary high water mark and then connected the dots, I came up with a shoreline that was 1 3/16 of an inch, which was 54.28 feet. And I guess in summary, I have concerns and questions about whether there truly is 63 feet of usable space for the applicant, or whether there may be closer to 53 or 54 feet of usable space for the applicant. And also just wanted to point out a comment that riparian or littoral rights don't exclude boats from being able to use the water. It's just, that's not what they're about. And then we will submit this as part of the record.
Okay, do you have copies for the other participants?
Yes.
Ms. Coppin, do you have any questions for Mr. Aaron?
Thank you.
Mr. Howard, do you have any questions for Mr. Aaron?
You not?
Is there any questions? So based on your new drawing, based on the inspection reports, do you agree with the depiction of the torrent lines provided in the application?
I'm exactly unsure how to answer that question, officer. It's a confusing matter. What I will say is, based on the inspection and being on site, I do feel that the shoreline is straight. So therefore, I feel that the littoral lines will be perpendicular to the property line. We have cases where sometimes the property lines meet the shore at a point, at which case the littoral lines would flare out. Or conversely, the littoral lines could reach a bay where the littoral lines would converge. This shoreline, although the Cooney County parcel webpage is definitely off, I feel that the shoreline in this case is relatively straight. And so therefore the littoral lines would come off from shore at a perpendicular angle. And so the crux of the matter is that width of their littoral area 63 feet? Or I'm sorry, 62 feet or 53 feet? Mr. Simpson had a deed when they were talking about the littoral rights that talked about the property, that talked about the property lines reaching the lake and then traveling along the lake shore for 53 feet. And the current deed for the Beats property says the same language. It reaches the shore, travels along the shore of Hayden Lake, but it mentions 63 feet. And based on the analysis that I did, I feel that it may be closer to the 53, based on the procedures that IDL follows as far as extending the property lines to the high water mark to determine where the littoral right lines are.
Oh, I'd like to bring up, can we pull up the one that has the,
I'm going to object here. This is the Department of Plan's
Oh, I'm
opportunity
sorry.
to present and speak.
I agree.
I'm sorry, I didn't know we.
Thank you. Next.
I'm just going to ask Jennifer Barker to present the Department of Land's hearing statement. It's in the record. She'll have some verbal modifications to it that she'll just sort of note as she goes along.
Okay, and actually, you know what, I may have missed that. So the Department of Lands is offering this exhibit to the record.
Yes,
I
thank you.
apologize. Mr. Helen, You have not been able to see this yet, like, having just been online. Is
I
it-
can scan it if you want, and then I can drop it somewhere, if it's any quicker.
You could also just hold it up to the camera real quick, see how
Well,
that works with this long.
You know, maybe let's start by this for ease of reference. Why don't we number the exhibit? And I was just double checking our hearing statement to see where we are in terms of numbering. Or do we just have one? We just have one, just the hearing statement.
I think your finger's covering
Yeah,
the
so I think we're.
highlighted spot.
No,
Mindy.
it's not, the highlighted is.
Oh, you got it. Oh, I'm
You
sorry.
mind saying that?
If we could just number it as IDL two, please.
Thank you.
And then I will let the applicant and objector raise any objections they might have to including it as part of the record, and I'll address those if that's okay.
Sure. Mr. Howland,
I don't know what I'm agreeing to.
okay. Was Emily going to
Just scanning it, yeah.
email? So, in the meantime, so hang time, Mr. Howland, we're going to try to get this to you electronically to have you take a look at this to see if you have any objections to this into the record. In the meantime, Mr. Arthenian, do you have any objections to admitting this?
Can we maybe go off the record for just a moment, please, and talk through this off the record? And then we'll go back on and put whatever we agree to on the record. Is that okay? Is that okay with you, Mr. Howland? I know you don't know what you're agreeing to. I'm just talking about going off the record to talk about a procedure.
That's fine.
All right, so Mr. Gosa, do you mind, it's 3:46 PM, do you mind pausing the recording?
The recording has been resumed.
Thank you. Okay, well, it's 3:57 PM. We're back on the record. So the first question that we have to answer, IDL has offered exhibit IDL 2 to be admitted to the record. Mr. Howland, do you have any objections?
No.
Mr. Anthony, do you have any objections?
I do not.
Okay, so IDL 2 exhibits has been offered and admitted into the record. So it sounds like, or go ahead, Ms. Kaufman, do you want to summarize?
Yeah, perhaps if I could just provide in some lead-in information. As I believe I previously indicated on the record, Jennifer Barker will be providing the hearing statement for IDL. IDL previously did prepare a hearing statement and submitted it to the hearing officer and to counsel as required by the notice of hearing and notice of appointment of hearing officer. That was, the hearing statement was previously stipulated, as were all exhibits by all parties. And it's been admitted as part of the record. As part of what the Department of Lands has heard today, and upon consulting with me as their counsel, they have made some, IDL has made some revisions to the hearing statement, which Ms. Barker will indicate verbally as she testifies on the record. And then what we did describe, or what we did discuss off the record, was whether then counsel for either the objector or the appellant would want us to prepare a new or revised hearing statement, or instead rely on Ms. Barker's verbal revisions on the record. The other thing I would note, and first of all, let me just say this, it's not unusual for IDL to make some revisions to its hearing statement on the record during the course of a hearing based on what IDL hears at a hearing. There's often new information or questions that need to be addressed. The other thing I would say that it is also standard for IDL to skip over portions of its written hearing statement for the sake of brevity although they would still be part of the hearing statement. Those portions specifically today are going to be the timeline that's a part of the hearing statement, and the provisions of law, applicable legal provisions, which is section 2 of the hearing statement. Ms. Barker will be skipping over those today. They're simply quotations of law with the exception of a discussion of case law. However, it is IDL's intention that those applicable legal provisions, all of section 2, do remain as part of IDL's hearing statement, even though she won't recount them in full verbally today.
Thank you. Mr. Hahn, do you have anything that you wanted to add as far as, making sure that what we have discussed off the record is accurately captured on the record?
I don't.
Thank
Thanks.
you. Mr. Hurd, I don't. Okay. I just would ask, would you make it abundantly clear and obvious to all of us where those changes are? Just so there's no question. It helped me.
And I note for the record that Ms. Barker is nodding clearly, so yes. Good afternoon. My name is Jennifer Barker. I am a lands resource specialist for the MICA Supervisory Area Office of the Idaho Department of Lands, and I am one of the specialists within the Navigable Waters Program at IDL. My purpose in being here today is to provide you with information regarding IDL's assessment of application for encroachment permit number L95S6007 application filed by Nick Beath, representative of the E3 LLC, which owns the property identified as parcel 51 North, 03 West, -04-7725 on Hayden Lake in Hayden, Idaho, otherwise known as the applicant. The applicant is seeking an encroachment permit for a single family dock located adjacent to a vacant parcel on the northwest shore of Hayden Lake. This parcel is described as parcel ID 51 North, 03 West, -04-7725, AIN 122741, and tax number 20773 in government lot 5. The proposed single-family dock would consist of a 4x10 pier, 3x20 ramp, 38x24 single slip dock, comprising 692 square feet. There is not an existing encroachment permit for this property. I'll skip ahead to the IDL analysis on page 7 of the hearing statement because the timeline and applicable rules are in the written record. I would like to point out the applicable case law included in the record as well, and this information would remain in the record. IDL's analysis of the application's compliance with the LPA and LPA rules. The littoral ownership, we'd like to make a change in that as addressed by our attorney. Just omit that portion from this statement. The type of encroachment, the applicant is seeking an encroachment permit for a single family dock. The application type would be considered a navigational encroachment. We would like to also omit the shoreline length as that has come into question. The square footage of the encroachments, IDAPA 20.03.04.015.01.b provides that a single family dock may not exceed 700 square feet of total surface decking area waterward of the ordinary or artificial high water mark. The applicant's proposed dock would be 692 square feet in size. The line of navigability, the proposed single family dock would extend outward into the lake 51 feet. The proposed dock is slightly longer than the 2 adjacent docks. However, it is not as long as other docks in the area and would be within the line of navigability due to the contours of the shoreline. The distance from the littoral lines, IDAPA 20.03.04.015.13.e provides in pertinent part that the single family docks will have an adverse effect upon adjacent littoral rights if located closer than 10 feet for adjacent littoral right lines, which is subject to rebuttal. At this time, we would like to change that section because we are not sure where the littoral lines should start based on the discrepancy in the shoreline versus the survey. The signature requirement, IDAPA 20.03.04.020.02 states that only persons who are littoral owners or lessees of a littoral owner shall be eligible to apply for encroachment permits. Applicant is the littoral owner. A person who has been specifically granted littoral rights or dock rights from a littoral owner shall also be eligible for an encroachment permit, the grantor of such littoral rights. However, shall no longer be eligible to apply for an encroachment permit. Applicant has not granted permission for anyone else to permit a dock from this parcel. At this time, there are no encroachments. It does appear that Mr. Simpson may have an easement on applicant's property. However, that easement is only for pedestrian and vehicular traffic and parking purposes. There's nothing in the pertinent deeds that provides access to the water for Mr. Simpson, nor is there any evidence in the deeds that applicant lacks full littoral ownership and rights. Notably, IDAPA 20.03.04.020.02 provides that except for water lines or utility lines, the possession of an easement to the shoreline does not qualify a person to be eligible for an encroachment permit. The possession of an easement does not qualify another party, such as Mr. Simpson, to apply for an encroachment permit, nor does it preclude the owner of said parcel, in this case, the applicant, from applying for the encroachment permit. In conclusion, IDL would like to recognize that Mr. Simpson is not an adjacent neighbor and did not receive the courtesy notice of application. However, Mr. Simpson learned about the proposed dock and did present an easement to IDL regarding access and riparian rights for the applicant's property. The dock drawings that were submitted by the applicant all appear to meet the single family dock standards that are listed under IDAPA 20.03.04.015.01. The proposed dock is less than 700 square feet in size. The proposed dock is within the line of navigability. No portion of the dock is wider than 10 feet. IDL feels that the applicant has the right to apply for a dock. However, based on the question regarding the littoral space, IDL is unsure. Sorry, a question about the littoral space and a question about the frontage. IDL is unsure how to proceed. And we do not have a recommendation at this time.
Ms. Coffin, do you have any questions for?
I do not.
Okay, Mr. Allen, do you have any questions for Ms. Parker?
I do not.
Mr. Hunter, do you have any questions for Ms. Parker?
Just briefly in subsector section G, on page 8. Says there's nothing in the printed deeds that provides access to the water from this Mr. Simpson. Or is there any evidence in the deeds that applicant lacks full littoral ownership and rights? I just wanted to verify that in reaching that conclusion and making that statement, you considered the various deeds that we submitted, the Verisec deed, the God deed. And there was a third one as well.
Yeah, what's this one right here? Schmitz.
The Schmitz deed.
You can just, no, it's a question to you. You can go ahead and answer it. Okay. So the Department of Lands feels that the deeds would have, they may not grant that the exclusive littoral rights, that they may just be a legal description of the property.
I'd like to follow up that answer if I may as well. Sure. That reviewing the deeds, the easement language specifically called out in the specifically called out pedestrian, vehicular traffic, and parking purposes on the following described parcel of land retained by the grantors, described as follows. It is in the legal description that we see the term riparian rights. If we had seen the term riparian rights in that above section, then it's very likely that IDEA would feel differently about the presence of the easements.
Thank you.
Any other questions? Okay. Ms. Coffin, do you have anybody else that?
No, thank you. Thank you very much.
Okay.
Mr. Hearing Officer, earlier in the hearing, you had asked Mr. Fry a question about the dock size. I looked at the drawing and did the math. That section was an 8x14 section. That is not matched. That is not labeled. That gets you to the 692 square.
Thank you. So I want to ask all three parties. Mr. Helen, would you like some time to provide closing arguments?
Oh, please.
Okay, Mr. Ruthenian,
I would.
Ms. Kaufman?
I'll reserve the ability to do so, but I doubt that I will have much.
Okay, so the order I like to proceed, Mr. Ruthenian first up, Ms. Kaufman second, and allow Mr. Allen as counsel for the applicant, the last word. Following that, I'll talk about the next steps and we'll conclude. So I appreciate everyone hanging in here for so long.
I have a question before we
Okay.
get off the record. With Mr. Simpson not being a direct neighbor on either side, if we do decide due to the change in, or if there is a change in the front footage, to spin this dock to 24 feet instead of 38 feet, like we facing with a slip out, and we have both adjacent property owners here, I'd like to get their opinion on that. So to see if we would have to go through the whole process again with both adjacent property owners here.
So the scope of this hearing is limited to this application and the record as it exists now. If if we want to take a recess, if the parties want to see if there's some negotiation, or we can all agree to some sort of change in application that everyone would be agreeable to. I'll go off the record and leave the room so you guys have to discuss, but
Unfortunately, Mr. Tone is no longer on the hearing, so I mean, one opportunity, depending on if it's acceptable to you, sir, is maybe to adjourn for the day and to set some sort of follow-up communication in that regard, whether it's another hearing or if it's through email correspondence. I defer to you. I know the rules of evidence and presentation are relatively loosened, at least at this stage. That's one possible option, but it is clearly a point that I would need to confer with Mr. Tone, given the fact that he is an adjacent parcel.
okay. Mr. Howland, what are your thoughts?
We would like to submit the matter today and get a decision. So I don't know about continuing the hearing.
Ms. Kaufman?
I tend to agree with Mr. Hallen. I mean, nothing at all, of course, would prevent the objectors and the applicant from conferring after the hearing at any point and attempting to reach a resolution. In fact, the Department of Lands encourages that sort of resolution as much as they possibly can, and to the extent it's whatever resolution is reached complies with the pertinent legal standards. But I do think it would be helpful to get this matter submitted today. And of course, if there is some sort of resolution prior to the date for the final order, the parties are always free to submit some sort of a stipulation and we can dismiss this proceeding or whatever we would want to do at that point.
Okay, oh, go ahead.
I was gonna say, not to be disagreeable, but I fully appreciate that perspective and the efficiencies of the whole process, but again, without being able to confer with Mr. Tone on the issue, it's something that we can't stipulate to today. So the application would be submitted.
Okay, I'm inclined to proceed with proceedings as set forth. After the closing arguments, after we outline next steps, we'll conclude this hearing. Parties are free to pursue a parallel process. I'm going to start working on the decision. You guys come to an agreement and fantastic, but I'm going to just go ahead and continue proceedings, continue down that process and go from there. I appreciate Mr. Breyer that bringing that up, and I hope that we created the parties to come to some sort of agreement outside of this. With that, Mr. Zanian, I guess the one thing I would just ask if we can keep the closing remarks brief. I'd appreciate that.
Sure. No, I'm not going to take too much time. I appreciate that. It's 4:15. We've been here for a bit, so the closing remark is fairly straightforward. Attorney Hoffman raised the point. Again, fundamental to our arguments, our point is the position that the conveyance deeds, the documents at issue, do in fact convey riparian littoral rights. That is our position. That's the position we're still forwarding. For instant purposes, I think the more dispositive point there is Byrd is fairly clear in terms of what the jurisdictional authority of the IDL is in terms of reaching a determination on that precise issue. Because even though Byrd talked about a situation of ownership of adjacent parcels one next to one another, here the comparable is there in terms of the ownership of riparian rights or littoral rights and the possible potential ownership of the same. So under the theory of the law that was presented and ruled upon by the Supreme Court of Idaho, the same analysis that was in play at Byrd is equally applicable here. So with all due respect to you, Mr. Hearing Officer, and to everyone who participated today, from a procedural perspective, again, we feel Byrd is dispositive and forces the IDL's hand in terms of denying the application as submitted. Thank you.
Ms. Kaufman.
I don't have anything further. Thank you.
And Mr. Howard.
Well, thank you. And to summarize, Reed Properties is proposing again to construct a single-family dock with a layout that still observes the 10-foot buffer on each side with respect to the littoral right lines, however they may be drawn. I think that the application conforms in all regards with the Department of Land's requirements for single-family docks. Now, the main objection that has been mounted in this case is that the applicant does not have, well, I guess if I understand correctly, that you're not asserting there's been a severance of littoral line or littoral rights, but there's an easement encumbering those littoral rights. And to follow and echo Mr. Ammer's comments, if you look at the conveyance language, it's very specific that easement was limited to pedestrian and vehicular traffic and parking purposes. It doesn't say anything about using the lake or enjoying the lake. And in fact, the only discussion or reference to littoral rights is in the description of the burdened estate. And it describes that portion of the property that lies upland of Hayden Lake and is described or outlined in, I think it's Exhibit A5. There's no language in any of the easements that remotely constitutes a severance of littoral rights or even a easement of those littoral rights. Again, that easement is expressly limited to pedestrian and vehicular traffic and parking purposes. There's been no suggestion here that the proposed dock would somehow interfere with the easement holder's ability to enjoy that limited easement area for those defined purposes. And if you look and follow the authority cited by the Department of Lands in the hearing statement, which is the Lake CDA investment case, the fact that it references an area that extends down to the high water mark does not constitute an easement of riparian rights. It does not constitute a severance of the riparian rights. So I think, Your Honor, our hearing officer, excuse me, giving you an appointment, a judicial appointment again, that there's no basis in this matter to deny the application of sheer fact that there's an easement that encumbers the upland area of the proposed dock area. So on that matter, I submit the matter. Thank you.
Thank you, Mr. Allen. All right, so as far as next steps go, I'm just going to read straight from the notes of the hearing officer and hearing. Says the hearing officer shall submit a preliminary order to the director of the Idaho Department of Lands within 30 days after the close of the hearing. After receiving the preliminary order, the the director shall issue a final order no more than 45 days after the conclusion of the hearing, or allow the preliminary order to become final 45 days after the conclusion of the hearing. As provided in Idaho Code 67-9240, the contested case provisions of the Administrative Procedure Act do not apply where the legislature has directed the use of alternative procedures. Because the legislature has enacted specific alternative procedures in Idaho Code, section 58-1305, that require a final order to be issued within 45 days of the hearing and leave insufficient time to consider petitions for review of the preliminary order, the procedures of Idaho Code 67-5245 addressing petitions for review of preliminary orders are not applicable. Again, I just want to thank everybody for their participation today, for their comments, for and during this time. I reached 4:21 p.m. Conclude this hearing. Again, thank you all.
Thank you.
Mr. Gosso, would you mind stopping the recording?